You've settled your personal injury or medical malpractice case, and now you are walking away with $500,000. Can you take that money and do anything you want with it? Can you go ahead and buy a Rolls-Royce? Can you buy a Lamborghini? Can you go ahead and buy a house? Would you like to know the answer? Come join me for a walk through the neighborhood as I share with you the answers to those questions. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The short answer is yes, you can pretty much do anything you want with it as long as you are an adult. If you are an adult and now you brought this lawsuit and now you were able to settle this case after expenses and after attorney's fees, you now walk away with $500,000. That money is yours to do whatever you wish. It would be different if the money was for the benefit of one of your children. That's entirely different. There are limitations and restrictions on what you can do with that money and when you can access that money or when your child can access that money. If you receive $500,000 for full and fair amount of money of compensation for all of the harms and losses and damages that you suffered as a result of someone else's carelessness, well, guess what? That money is yours to do with whatever you want. If you want to go ahead and spend it on a car, you can go ahead and do that. If you want to buy a house, you can do that. If you want to buy jewelry, you can do that. Is that a smart thing to do? The answer most likely is no, it's not. Your goal is to try and preserve that money for as long as possible, and there are different methods and different ways to do that. But let's go back to the question I raised in the title of this video. Can you do what you want with this type of settlement money? The short answer again is yes, you can. Now, here's something interesting. Many people think that when they receive a settlement like that, at least in New York, that money is taxable. Well, I'll share something with you. The answer is that's incorrect. Why is that? It's because the pain and the suffering that you endured as a result of someone's carelessness, that is not considered taxable income. Why? Because you did not earn that income. That is not considered earned income. You did not work to obtain that money. Instead, you are being compensated as a result of all the harms and losses and damages that you suffered for the carelessness, for the wrongdoing, that now you are not taxed on this money. So you can take that money and then invest it. You can do whatever you wish. You can buy a rental income property. You can do many different things with that money. The goal being to preserve it as long as possible, to use it for your children, to have it so that you can pay for your children's college education and any other things that you need to do. People often wonder, hey, can I do anything I want with my money? The short answer is yes, you can. So why do I share this quick information with you? I share it with you to open your eyes and help you understand what happens in these medical malpractice and accident cases here in New York. You know, I recognize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.